this webinar. Today we'll be discussing disciplinary procedures. It's very important for everybody to be abreast of, everything that pertains to disciplinary procedures. And today we have a very, very experienced person to lead in those discussions. If today is your first time, I'd like to officially welcome you to Lawyers in the Corporate Space webinars. If it's not your first time, welcome back. We started this project sort of as a continuous legal education for in-house lawyers particularly, but hey, if the information is useful to other people, why not? My name is Commander Rtd. I'm the in-house lawyer at Senate Energy Limited. I have 9 years experience, 3 years I started with Intravenco, and for the remaining 6 years, 5 years, 6 years, yes, I've been with Senate Energy as in-house. So first-hand experience, I know the things that we really need to know and really need to learn. And I'm hoping that we can use this platform to share and let everybody else benefit from it. We've had a couple of episodes already. We've uploaded them onto YouTube. So if you go onto YouTube, Lawyers in the Corporate Space, Ghana webinars, you will find the past videos there and you can watch them and benefit from them. And I hope that you share as well. You can find me on LinkedIn, Rtd, and you can give me feedback. You can contribute to these things remotely. We have people who have always been in our corner, been rooting us on, and have been coming with suggestions. We're very, very grateful. So we're hoping that the more people are involved, the better, so that we can all go together. This is some sort of mentorship series where we come in close contact with pioneers and even with our peers so that we can learn from them. So today we'll have a pioneer leading us and talking to us on disciplinary procedures. Because it's primarily mentorship, we don't particularly emphasize the projection of slides, but if the speaker is minded to, then that's fine. That's very welcome. But we'll try and make it as conversational as possible so we're not too bored. And also, we expect that it would be a very, very useful interaction. We asked people to send in their questions, and people did. Thank you very much for sending your questions too. During the presentation, if a question is not addressed, I'll note it and then I will ask the speaker. But yes, you can put questions in your chat box or raise your hand and we can give you the opportunity to ask a question in case we haven't addressed it already. So that's that from my end. I'm now going to hand over to Mr. Samuel Allotey. He is Wing Commander Retired, and he is also a lawyer, and he will be leading us in today's discussions. He will tell us a bit about himself so that we can, know his journey, where he came from to where he got to, and hopefully it will inspire us all. So, Mr. Allotey.
Okay, thank you very much, Bridget. And welcome to everyone on the webinar. So as Bridget mentioned, I retired from the Ghana Air Force after 18 years of service as an avionics engineer. But sometime during my stay with the Air Force, I thought of the career change. I wanted to move into the space of human resource management. So I took some studies. My master's program was in the States, and that helped me make my transition from the Air Force into the civil world, back into the civil world. So I worked with Africa Online from 2001. 2004, I was the country manager for Africa Online in Uganda. 2006, I was the group head of human resources in Nairobi, Kenya. And I decided to come home because I was missing my family. The money was good, but I realized that there's something beyond money, so I had to come back home. So I came back and I joined Stanbic Bank. I stayed with Stanbic Bank till late 2011. Then I joined the Ghana Grid Company, and I thought that's a place I should stay till I retired. So I spent 9 years with the Ghana Grid Company. Now, in between these career transitions, I thought of taking a professional course, and I chose law. So I had the LLB, then I followed it up with the barrister's program, or the QCL, as they call it. Currently, I'm on retirement, as you can see from the long journey and years that I've accumulated. I am an independent with integrity solicitors and advocates under the mentorship of a good friend, lawyer Alija. I also do adjunct lecturing for GIMPA in public sector management, and a management consultant, basically helping organizations with their industrial relations issues, extensive work with the mines. And so pretty much that's what keeps me busy. I hope, Bridget, I've covered every base. Bridget, do have you muted?
Oh, yes, sorry. Yes, you have. You've given us a lot, but I'd still like to know what are some of the highs and lows in your career? It's been a long journey for you.
Okay. Looking back, I think the first one was my transition from the armed forces, leaving the armed forces. If you have a love for the job and you've done it so well for 18 years, something must really chase you out. And for me, nothing was really chasing me out, except that the structure at the time, the organizational structure, was that I'll have to wait for a long time to move to my next rank. I thought that was that's not a good thing to do. So I applied for voluntary release, and I was released to go and pursue other interests. So, and then also in terms of the expatriation, when you have to work outside your home country, sometimes your priorities change. You reflect and realize that maybe it's about time you've had enough. It's about time you go home to take care of, other more important and critical. Yes, especially the children. Otherwise, they would grow without you. In the military, I did a lot of traveling and out of station, out of base deployments. So it suddenly got to me, and I said, no, I had to come back. So those were the two, I think, major transitions. As for the passion to do law, I've always had it at the back of my mind that I need that for my work. So my elective was labor law, beyond all other things that we had to study here.
And what would you say has been your greatest achievement, the highlights for you in your career?
Oh, I would say for me, the career has been the transitions and the fact that if I set my mind to do something, I see it through. Maybe the laurels I received in my military career are some of the things that I look back to, especially my senior professional military education in the US. That was a turning point for me.
That's nice. I'm sure somebody is also inspired by this journey to know that whether progress is this way or it's this way, it's still progress. And just keep working hard, deciding this is what I want to do. And at every point in time, reviewing the journey and trying to move forward. So thank you very much for sharing about yourself with us. And so now we will go into disciplinary procedures, why we've all gathered here today. And I trust that we are going to leave enlightened by all the wealth of knowledge that you have to share. So please, over to you.
Okay, thank you. Thank you very much. So, as you mentioned in your introduction, I thought that for the type of discussion we'll be having, it will be useful to have some framework around which to build the dictionary procedure discussions. So I just put together a few slides, not many, just to set the space for us to play this discussion game. I also took into consideration some of the questions that were asked, so that I've gone through the few slides I have. Some of those issues will be addressed. Then we can engage on the specifics. So, okay, once participants can see it, then I can proceed. So just give me feedback, Bridget.
Yes, please, I will.
Okay. So we'll be looking at the legal framework. I believe the majority of participants are in the legal profession. Some also are in the human resource management space. So look at the legal framework. Why do we have to have disciplinary procedures in the first place? And then we look at the disciplinary system. Then we walk through the procedure step by step. And a question was asked as to what principles, or rules govern the disciplinary procedure. So we're looking at the principles of natural justice and the areas where people have the greatest problem with some disciplinary actions is that they believe it's unfair on the part of the employer to sever the employment relationship. So we'll touch briefly on sections of the Labor Act 2003 at 651 so that we can avoid some of the pitfalls by ensuring that there's compliance with the provisions therein. And then just a word to conclude. So someone asked, what is a disciplinary procedure? And the HR suite gave this definition, which I thought was apt. It says it gives management a framework for upholding acceptable standards. Acceptable standards in terms of technical standards and behavioral. And also gives the employees access to channels through which alleged poor standards, conduct, and behavior can be treated fairly and appropriately. The operative words here is the fair treatment and the appropriate treatment. Because without the disciplinary procedure, we'll have what someone calls Spanish customs. Everybody will be doing the game as they think fit. So some framework, some legal framework must be put in place to guide how disciplinary issues are dealt with. So, and the process, I'll just touch briefly on the process before we go into some of the reasons why you have to follow this process. So first of all, you have to understand the issue. You don't jump at the first report that you hear. You have to request for information so you can understand the issue. And that is why you either issue a request for information or what some know as a query, that your conduct or omission has violated a specific provision under your terms and conditions of service, and that you have to explain why disciplinary action should not be taken against you. So then you can get an explanation that would end the process, because of course there was grounds for the conduct or that behavior. You might also decide that, well, you might have to just give a verbal warning. So we'll come to some of the disciplinary actions that you can. But first, and most critical, you have to understand the issue. Sometimes the issue is not so easy to understand because there are too many moving parts. So you have to investigate thoroughly. So audit sometimes is called in, or you can empanel an investigative team. Just get a few people to, look into the issue and let you know exactly what happened. Now you have to follow a fair procedure, the principles of natural justice, and the progressive discipline approach. Now, when we talk of progressive discipline, the saying that you don't use a sledgehammer to kill an ant is what undergirds the progressive discipline. You don't, if somebody, does some misdemeanor or goes foul of the law, if it's not gross negligence or something that is weighty in terms of the gravity of the offense, there are progressive disciplinary things that you have to put in place, or progressive disciplinary actions. That is why we have the scale of punishment depending on the weight of the offense. Now you have to follow the disciplinary code. This is very critical. And the disciplinary code must be prescribed for the organization. So the organization must say, these are our values, this is what we want to live by. And then they draw out a schedule of offenses, things that the organization frowns on, and for which they have to prescribe the applicable sanctions. Next, you have to communicate the disciplinary hearing outcome to the employee. Sometimes this is where HR or the people who handle the process think that once the disciplinary committee was convened under the authority of the chief executive, the report must go to the chief executive, and then straight a termination letter comes. That's not the procedure. You must communicate the outcome to the employee or whoever is alleged to have committed the offense. Then there's a right of appeal. So once you communicate that, if the employee thinks that, okay, I mean, it's fair, or if they think that during the hearing, something that infringed on his rights, and he wants to bring it to the disciplinary authority, the law requires that you allow him or her to do that. So it's after that has been waived or executed that you can apply the disciplinary award. Because sometimes after the right of appeal, the punishment may be mitigated by the disciplinary authority, who is, in this case, is the MD or the chief executive. Now, I've put in bold that you must document all procedures followed and the outcomes at each step, because you cannot oust the right or the jurisdiction of the courts if the employee so wishes to seek redress. Then you have to produce evidence to the fact that the procedure was fair and appropriate, that it was also legally grounded. So what are some of the disciplinary actions? So like I said, if you get the response to the query and you think that, okay, this is a first-time offender, he might have erred on the side of caution, so a verbal warning, yes. If you think it's a written reprimand, you can do that. We call it the warning letters. Now, there is a third one, which is tricky. That is suspension. Now, Section 69, subsection 2A of the Labor Act 2003, Act 651, prohibits a pecuniary penalty of any kind. So why is it that we are still carrying the suspension date. I will explain that in a minute. The demotion too is something that talks to the pecuniary penalty, because once you demote somebody, you make the person financially worse. So can that not be interpreted as a pecuniary penalty? The fifth one is termination, is an action, which means that the nature of the conduct or the offense has marred the employment relationship. Now, I must also state that termination is not only through disciplinary actions. It is a disciplinary action, but termination can be for other reasons that we'll be seeing in the next few minutes in the slides. And then, of course, the last one is dismissal. Someone asked the question that interdiction, is it a disciplinary action? Interdiction is not a disciplinary action, but an administrative process to avoid interference with investigations. And there is a legislative instrument, that is LI 1833 of 2007, regulation, no, sorry, 1833 of 2007, yes, regulation 8 talks about remuneration during interdiction. So interdiction is not a disciplinary action. And if after the investigations you are found not guilty of the allegations or culpable, your whatever amounts were withheld are reinstated. They are restored to you. So the suspension and demotion, normally it's aligned to the progressive disciplinary principle. Now look, we can terminate, but the disciplinary authority says, I've invested so much in this person, he's been of good conduct all these years, I want to give a lesser punishment. And then the question is it fair? Well, is a termination of employment better than demotion, or you opt for the demotion? So, like I said, although it has a pecuniary a penalty nature, it is a mitigated action from something more severe. Now, as to the legality of it, is still being debated. That if the law expressly says there should be, it prohibits a pecuniary penalty, why are we still carrying them in our books? I'm sure during the discussion we'll have views on that. So what's the legal framework? First of all, if you get into the 1992 Constitution, Article 11, which is a whole chapter, Chapter 4, talks about the laws of Ghana and refers specifically to acts of parliament. Article 109 specifically gives parliament the mandate to come up with acts that regulate how businesses and organizations are run. And that is why we have the Act 651, being the Labor Act, to govern the employment relationship. Now, within the Act 651, we have a Section 8, which talks to the right of the employer to discipline. So it's the employer's prerogative to discipline. Now, when you get to Section 15, it gives the grounds for the termination of employment. And as I mentioned earlier, termination is not a disciplinary action, although it can be a disciplinary action. In the first instance, it can be by mutual agreement that we end this contract. It's not working for both parties, or the employee can allege ill treatment, or the employer can also allege the same, then sexual harassment, there will be grounds for termination. Death of the worker obviously terminates the agreement. So the employment relationship is severed. Now, you can be declared unfit for employment on medical grounds by a medical practitioner or medical board, and that will also terminate the employment relationship. Now, the inability of the employee to work also constitutes grounds, which is sickness or accident, which is medical, incompetence, which is performance, and proven misconduct. So these are the grounds where the termination, that is the EII and EIII, where you now have it coming in as a disciplinary action. So the sanction for incompetence has been provided, that termination is the appropriate sanction, but it has to be proven. So we have to look at the procedure for proving that. Now, if you come to fair termination under Section 62A, it also says that you can terminate on grounds of incompetence. But it's amazing that most of our performance appraisals do not flag poor performance. Everybody, on a scale of 1 to 5, everybody is a 3 or 4. So the general rule is that you cannot just allege incompetence without proving it. And the reasonable procedure to follow is that you must identify the poor performance. You must notify the employee and then take appropriate action, which is performance improvement programs. Now, for performance improvement programs, the PIP must monitor the performance and provide periodic feedback. Now, during this period, if you put an employee on PIP, you have to be sure that you provide specific targets to be achieved at each stage during the period. You have to document the process so that you avoid risk of unfair termination. You have to notify the employee in writing as to your final assessment. Not that you keep things under wraps and then the next thing he sees that is being terminated because of incompetence. And of course, during your feedback sessions, make sure you take minutes. What specifically was done well, what didn't go well, what corrective actions you suggested, how well those were carried out, and you ensure that the employee signs up on the documentation. Now, the best practice is that if somebody is not pulling your weight, you must terminate with notice, because definitely the progressive disciplinary approach says you try a performance improvement, and if it doesn't work out, then you should notify him that on such and such a date, the employer no longer seeks to continue with employment relations. Now, for misconduct, it follows the disciplinary procedure. I'll be talking about the disciplinary committee that must sit on it. But the basic definition of misconduct is that it's an act which is incompatible or inconsistent with the faithful discharge of the employee's duties. As we said, you must have a schedule which describes, because the law, the Labor Act, doesn't define what is incompatible. It is the organization based on your values that you build that disciplinary code. And within that disciplinary code, there must be a fair process and in good faith. Don't punish people strongly for misdemeanors, which will be minor infractions. You can't have a that is, unfair and in bad faith, just because you want to get rid of some people. So what are the principles of natural justice? When you look at the human rights, fundamental human rights under Chapter 5 of the 1992 Constitution, all the articles there are talking to the need for administrative bodies to act fairly and reasonably. So the Article 19 in Chapter 5 of our Constitution talks to these issues. The first is the right to be heard. I believe most lawyers understand there's the need to hear the other party. And the offender must be fully aware of the case at every stage of the process, what the charges or the offenses are, who is coming to testify against him, and the opportunity for him to ask questions. Now, somebody asked, will the query suffice to satisfy the principle of a fair hearing? And the answer is yes. So the query is a request for information. So once you get the information and you understand the grounds for the conduct, and you think that it meets, that there's nothing else there's no case, then of course you can, you've heard the third party. But where it's going to lead to severe punishments other than a verbal warning, then of course the person must be called in to defend his position or her position. Now, no person shall be a judge in his case, and we're saying that this is to avoid, bias or partiality. So we don't want a conflict of interest. We're not only talking about the person who is alleging the offense, but the investigators and persons with some interest in the case. If I have a problem with director audit, then everybody knows that in the past, and I've run into another difficulty, and it's to investigate my case. I think that I would rather point out that he should recuse himself for someone else to do, because the head of the earlier engagement might influence his judgment. So we want to be sure that the bias need not be actual, it's the likelihood of it. So the person saying that, oh no, me, I'm a fair-minded person, I'm not going to use that issue against you, the likelihood that it can come in must be taken into account. So if the offense will lead to dismissal, then we expect that these 3 steps must be followed. The query, then there must be a disciplinary hearing to discuss the situation and to determine the culpability of otherwise. The right of appeal, includes an appeal meeting. It should not just be he writes a letter, he's not called, he's not given, then the next thing he receives a termination letter. That's not the way to do it. Now, the right of the employee to be accompanied by a colleague, because sometimes it's very intimidating to appear before a disciplinary panel. You see all the big wigs staring at this young officer. And so somebody accompanies too. And if the person is unionized, the union will want to have a representative. Now, the disciplinary committee, the composition varies from organization to organization, but it's generally of an odd number. If the person is unionized, they want to have a rep on it. But the issue then is that the person is there as a neutral person listening to the proceedings to help the panel take a decision that is fair. Now, when managers want to give a final warning, they should have a colleague around them, because you don't want, it will be disputed. The person will say, no, he didn't understand that he was going to be giving a final warning. So there should be somebody to witness the process. So I've itemized what we do for disciplinary procedure using the fair and good faith principles. I believe during the discussions we'll be talking about. The two things that I want to point out here is that the interdiction is to allow for investigations to be carried out, and the disciplinary authority is the MD, the chief executive, or the president, the highest authority in the organization. So we're almost done. I've mentioned the union being present, an extract of the investigation report. The disciplinary hearing must also seek to clarify the facts and not be adversarial. Yes, I want to point this out. It's not a court. It's an educating body at the enterprise level, but it's not a court. It's not to find fault or use a technicality because you didn't file this process by this time, you are out of time. No, that's something we should be mindful of. Principles of objectivity, impartiality, and decorum must always be upheld because look, we are talking about employment issues, bread and butter issues. These are weighty issues that must be carefully considered. Now, the outcome of the hearing should be communicated to the disciplinary authority with the findings, observations, conclusion, and recommendations. A few times I've received disciplinary reports from the chief executive and realized that they did not follow the disciplinary code. So there's the need to send it back to the chairman and flag the areas of the Axis 51 that they should address their minds to. Then I've talked about giving the offender an opportunity to appeal before a disciplinary award is given. It's an administrative process, not legal proceedings. The standard of proof is reasonable belief. We are not looking at whether it's beyond reasonable doubt, circumstantial evidence. No. As the maxim of the legal profession says, it is better for 9 criminals to be set free than for 1 innocent person to be jailed. That is what the law seeks, not to kind of restrict people's rights and reasonably. The burden of proof is on the one alleging the offense. And the disciplinary committee does not house the jurisdiction of the National Labour Commission or the courts. Whoever is not happy with the outcome can seek redress at these areas. So the remedies, should you unfairly terminate and the commission comes in, will be to either reinstate the worker, re-employ the worker on terms reasonably the same as what he has lost by the termination, or pay compensation. The aggrieved employee still has the right to sue the court. So that's it. Legal practitioners have a responsibility to avoid employment practice liability arising from poorly managed disciplinary processes and terminations. They have to avoid legal proceedings. So, when the disciplinary report, hearing report goes to the chief, 2 people that will have to look at it is Director HR and Director Legal, because you need your comments, whether all procedures and policies have been followed, and whether we are not infringing any act. So thank you for that. So that sets the background to the disciplinary procedures. Back to you, Bridget.
Thank you very much, Mr. Allotey. I don't know if you noticed, but I was busy taking a lot of notes. So I have a lot of questions to ask you, and I've seen that some people are also posting in the chat. So my first question would be that you said the highest authority is the MD or CEO, and those are the top. What if they are the people that the employee has offended?
There is a grievance procedure in the organization which complements the disciplinary process. So if, let's take sexual harassment. If the one at the top is the one doing the harassing, then the issue is that you have to go to the next higher authority, which is the board.
Okay.
So you can write a petition. Yes, say that, look, the MD has stepped out of line, and he's the highest is the disciplinary authority. I don't know who else can discipline him. So I'm sending a petition, and then you copy him. It will be nice to, you say that sexual harassment is what? Repeated unwanted sexual advances. Some say one time is enough, but I say that, look, if you want the person he backs off, that all well and good. But if he doesn't, then of course, you have to use whatever the policies allow. That you have to go to the next higher person to try and impress on him or her to desist, cease and desist from those acts. Most times, out of fear of victimization and out of fear of, what do you call it? Old boy network, you're afraid that if you go, but like I mentioned, if it's disciplinary, you have other recourse beyond the enterprise level.
Okay.
Yeah.
If you have that, by then it's
Somebody has to mute his mic.
Same as now, or is it? So yeah, just 0.53.
Okay, I'm sorry about that. The next question I have is, you said when you receive the reports, you go through to flag things. If there are certain things that you flagged, do you require them to go through the process all over again? Supposing it's...
Yes, it goes to the chairman of the committee, so let's assume that they had, jumped the gun. They have come to some conclusion that is, like it says, expressly unreasonable. You don't change anything. You're not the committee, you don't have the power to, but you can only flag it. So you send it back to the chairman. He will convene the members to look at it. And if they refer to the appropriate sections of the disciplinary code, they might rectify it and bring it. But I've seen instances where people have tried to change the committee's report. That doesn't lie with director legal or director HR. You should go back to the chairman with your guidance for them to do the right thing.
Thank you.
It's like you adjudicating yourself.
At that point, somebody has a question. Is it right for an employee to be punished twice for the same offense? Where perhaps in 2024, there was a query, you appeared for a panel, they took a decision, and then some years later, maybe a couple of years later, you find that the person is being demoted, and it feels absolutely like it's connected to the first action that happened.
Okay. There is this principle of escalation in terms of the sign. So you might have a first written warning, a second written warning, and then the third time is like you are becoming the problem now. So the organization will want to just take a more severe action. Now, these must be part of the disciplinary code. We don't want to ambush people, along the way. So if you are told that, look, 2 strikes, the third time you are out, then that is what is going to happen. Because somebody can keep repeating the same offense. So the escalation bit is there. The other challenge that we have is that sometimes we have something we call the horn effect, which is the opposite of the halo effect. Halo effect is that I did something good. So everybody knows how this lady always does great things. So when they hear a story or something else, no, they don't believe. The horn effect is the other one. You did one bad act for which you've regretted, but still in the memories of people. Then you realize that whilst you're trying to change to be better, it's still following you. You know, some opportunity comes, you have to be sent maybe abroad for some training. They say, no, no, this guy, we can't trust his behavior. Let's send his subordinates. You know, it's difficult to fight those. But if it is an express discriminatory act, you think that this 2 years ago issue is still playing in your career progression, you can raise it as a grievance.
Okay, so I hope that your answered. It's not right, but the employee can also raise as a grievance. There's another question here. Where a disciplinary policy specifies that particular person should be on the panel and an officer nominates another person to be on the panel, can the employee challenge the process, challenge composition of the panel?
Normally, the composition of the panel is based on representatives. So if a union is supposed to bring a rep or management is supposed to bring a rep, it's not tied to a particular name. I mean, the organization exists into perpetuity, right? People join and leave, and the organization is still there. And the policies have a semi-permanent nature, you know. So you don't want to put names, but you put appointments and units, you know. So reps from the union, reps from management, from the department. That is how you form the company. But I must add that normally we overlook the most important thing. Anybody who is likely to sit on the disciplinary panel must be trained, because there are technicalities, you know, in what the process is. So it's always good to have some training so that you don't, otherwise you have a panel that goes to debate amongst themselves instead of addressing the issue, because they're coming from different perspectives.
That makes a lot of sense. So there was a question about the role of the in-house lawyer in disciplinary procedures. And in your presentation, you mentioned that it's important that the head of HR and the head of legal review the report. But apart from that end stage, and apart from whether the policy says a rep from the legal department should be on the panel, what else can an in-house lawyer do in all of this?
You need a legal rep to be on the panel, because I mean, you can have maybe the department being an engineering department, there's been a safety breach, disciplinary issues have come in, emotions are high, you need a cool head. So you get someone who says, no, you can't do this. This infringes on the right of the employee, or yes, this is allowed, so that it guides the outcome. You know, because you want to be sure that what comes to the chief executive, which is likely to refer to the HR, it's of a certain good quality. That all that you have to do is that they endorse the recommendations of the disciplinary panel. That's all. So it's advisable to have a legal rep on the panel. It helps, but you know, sometimes they are hard pressed for staff themselves, you know, to be on those panels. So the training helps, so that you let people know that it's not an adversarial, it's not a witch hunt. Issues of impartiality and non-discriminatory issues are all addressed.
Thank you very much. There was another question, especially on summary dismissal. If you could please harp a little bit more on that one. firing somebody on the spot for a grievous, offense. If I can add this story, there was a company which ran a restaurant and they fired one of the employees because they said they were making losses on the breakfast session. And the employee was fired, took it to the National Labor Commission. And her response was, and to my shock, her response was, why was she the one who was fired? Because everybody else does it. And she came there with her union rep. And I was so shocked that she would actually say that. She doesn't deny she took it, but I guess her defense is everybody else is doing it. Why did you pick me out? So, yeah, so could you please help on summary dismissal for us?
Okay, so summary dismissal normally goes with gross misconduct. Something that goes to the very core of the employment relationship. Assuming in a situation, maybe in a deba, a head of department says something, and a colleague, assaults and gives him a slap. Yes, that's a gross misconduct because the disciplinary code or the policies will have a clause that frowns on assault. But it doesn't mean that on the spur of the moment, the person is dismissed. No. It was obvious, there were witnesses and everything, but the person must be given a hearing. Why did you do it? Now, you know that, like I said, it's not a law in the books of most organizations, but I know that in law, provocation is a defense. True or false? Bree.
Yes, it's true.
Yeah, provocation is a defense. Yes. So it will not be, yes, it's summary dismissal, meaning that you are fired, we'll fire you. But the law says that you must still hear him. So it's summarily, but it doesn't extinguish the need for hearing. He's fired. But you can't say, oh, ladies and gentlemen, you all saw it too. It doesn't cure it. Because we must understand his side of the story.
Okay. Thank you very much.
It might be mitigated from hear the story from dismissal to termination with benefits.
So it's important to know that with dismissal, you walk away with nothing.
Yes. Except your leave and things that are due you, but
yes.
The organization's tax, like your provident fund, the aside of the provident fund, those two things, bonus and those perks are all denied.
Okay, thank you. The question that brought about the Horn effects. So she said that the person raised it as a grievance, but it appeared nothing came of it. Is there a next line of action you could recommend for such a person who was punished a few years ago and is demoted again some years on?
Yeah, you see, sometimes the legal people in the organization should play an advocacy role. You see, you and I know that the double jeopardy rule, you can't punish somebody twice for the same offense. So the legal person should advise the chief executive. So when the grievance, of course, the grievance procedure has an inherent escalation. The supervisor does nothing about it. Your manager, your head of department, the chief executive. By the time it gets to the chief executive, the head of legal must advise. Because I've mentioned that the employee has recourse to the National Labor Commission or to a court of law. And you don't want to pull the organization there. That's what we call the employment practice liability. You're just going to, put a dent in your brand. So it's advisable for the chief to refer these things to the head of legal to advise. Is there a case to answer? And what can we do under the circumstances?
Thank you, Mr. Allotey. There's another question for you. Supposing there's a hearing against one person, and when they called somebody as a witness, that person inadvertently implicates himself or herself. When the panel comes out with the reports, do they attempt to perhaps say punish the witness who implicated himself or herself, or they have to now conduct separate proceedings for that unfortunate witness?
I think they have to, the right thing to do is to do, because he was not the one on trial, if I may put that in quotation. He's not the one on trial. So if he's incriminated himself by saying, oh, on that day I was there, or Kwame told me, but I didn't take him seriously. Say, oh, so you are aware of it. You report to management. So you are now culpable in the act. It will be wrong to put that in a disciplinary report. It was not set up for an offense. In any case, who has alleged the offense? So the disciplinary hearing will finish what they are doing. They might comment on it, but it's up to the district authority to decide whether, look, I want you to investigate this issue, the culpability. But they cannot punish the person or for that incriminating statement. You know about the Miranda rights, that people should be cautioned before they make statements that can be used against them. Yes, that's right. So the person has not been given the right to think of, what he was going to say. He was being questioned and he said something, and yes, he has implicated himself. But the hearing cannot, they can only make a comment on it.
Okay.
That Kwesi Ama, connived or had knowledge of this incident.
Okay. There's a question here. I feel sorry for the supervisor. What advice would you give a supervisor who has troublesome staff? The supervisor has tried to manage, issue the query, everything that you can imagine. Then this troublesome staff turns around and files a complaint of harassment against the supervisor. And now the supervisor is required to respond to the false complaints.
See, so you first have to look at, I've been sharing this joke with friends that an HR practitioner or a leader has no power except that given to him by policy. See, you don't have any powers outside what the policy gives you. So you first go to the section 15E. Then realize that there's the competence issue and the misconduct. Those are grounds to discipline a staff. Now, if the person is technically good, you move away from the competence. Now, the conduct, is he living the values? What is the nature of the troublesomeness? What is the trouble here? And if the person is not a team player and stuff like that, then you can bring disciplinary issues on the basis of conduct. But it must be well documented. 2, you have to find out from your disciplinary code whether that conduct, has been covered. Because in the Constitution, in terms of rights of the accused, Article 1911 says that nobody has committed an offense except that offense has been stated. There's a law that makes that conduct an offense, and the appropriate punishment has been prescribed for it. So If you say the person is troublesome, you have to go and look into the disciplinary code. Does that conduct fall under major offenses, minor offenses, misdemeanors, before you can act? But my advice to the supervisor is that sometimes there are some reasons behind people's conduct or misconduct, those behaviors. And it's for the leader to assert himself and to let the person know that this can lead to disciplinary.
Thank you. Another question is, what is the role of the investigation officer in the process?
Okay. The investigation officer, that's an independent inquiry, gives a report to the chief executive, on the basis of which the disciplinary committee is formed. Of course, the members avail the report to know specifically what they'll be looking out for. So the terms of reference sometimes is built on the back of the disciplinary report, what the findings are. Then, like I said, the disciplinary hearing is to clarify and to be sure that, yes, these things happen, and then determine the culpability or otherwise of the employee for the offense alleged. So the disciplinary officer doesn't come in, but if the committee needs them, needs him or her to come and clarify some aspects, then they'll be invited.
Okay.
In some disciplinary hearings, what happens is that they more or less play court. They have someone who comes to present the case of the organization, and then the employee, maybe with the union rep advising, would pose questions to them, But like I said, it should not be adversarial. You've done it or you've not done it. And if there's reasonable belief that you've not done it, you must be set free.
In the matter of saying, in the manner of saying, the set free.
Yeah, in the manner of saying that, you should be told that the facts alleged could not be affirmed.
Yeah.
For instance, you said that somebody has taken some money, right? So a disciplinary inquiry has been formed, and then you go into the logs because you have to show that you can't balance your books, but the books are balanced. So where's the missing money? So it's not that every disciplinary, and that is why the investigation is very important, because the investigations might tell you that, look, this thing, yes, it is alleged but cannot be substantiated.
Okay. There's another question here. If a doctor declares a staff unfit for work, how do we handle such compensation before the staff is terminated? Especially if the ailment means the employee is suffering from, you can tell it's a result of the work that the employee has performed over the years. I'm not sure this is a disciplinary procedure question, but we are here.
Okay, that's right. So, still under reasons for termination, section 15 of Act 651, sickness or accident can lead to that because you cannot do the work for which you were employed. The workmen's compensation is a channel for addressing injuries relating to the employment of the employer. So they'll determine the level of incapacity, and the compensation computations will be done. Some organizations have insured their staff so that these financial obligations do not ambush them, so to speak. And then that is rolled out to the insurance company to to make the payment. Now, if there's no insurance company, then of course the degree of incapacity and the computations thereof, based on the act, the organization will have to pay. Now, there are also provisions on extended sickness. Most organizations realize that sometimes it might not be grounds for termination, but you just have to reasonably accommodate, the situation up to a time when, with the hope that the employee will recover and return to work. But if it turns out to be one case that is drawn on, then you organize the medical board. And the medical board will advise that the person is unfit for employment due to incapacity, medical incapacity, and then appropriate compensation paid. So it's good sometimes to have, some guidance in your terms and
Very handled.
conditions.
Yeah.
Have salary for something, full salary for a period, so that once the person has signed up to it, that is what the Labor Commission will hold you to. Should the matter come before them.
Mr. Allotey, in your experience, have you ever come across language that you find are unhelpful that are used in the proceedings? And I'm saying particularly on the part of the panel or in the reports or from the investigative officer or from the supervisor issuing the query. Is there some language that you really advise people to refrain from using because it's unhelpful in the end?
Yes, one such word, accused. I don't think it is appropriate. The person has committed an offense. It's an offender. Accused of a crime. I don't think if it's a crime, if it's a theft, then you know that it is not to be adjudicated at the enterprise level, or that the enterprise can say that he's misconducted himself, he didn't exercise the duty of care, and then you can take him on. If you want to recover whatever the guy stole, the options are that: are you going to sue to recover, or he has some amounts with you that you can settle? So, calling people accused persons, I don't think it's the way to go. Otherwise, the process. I mentioned that there should be decorum. The fact that somebody has misconducted himself, we should not, demonize the person, if I may use that word. And we are all likely to make mistakes at one point or the other. Some are more daring, so they do more grievous ones. And we should be fair in the procedures and not vilify the person or make it look bad. But calling people the accused, I don't think they are. It's an appropriate language at the enterprise level.
There's another question here. Where a specific offense falls outside the scope of offenses listed in the disciplinary code, can management still go ahead to dismiss the employee on the basis of their own conviction on culpability of the staff after they've done a hearing?
Yes. You see, normally we look at the principles before the practice. So
Okay.
you have a disciplinary code which has listed all the conceivable offenses. Then you realize that somebody secretly went and changed passwords to lock others out of a system. knowing very well that the standard operating procedure means if he's closing for the day, he should hand over the passwords. And then for some reason, he cannot be reached out of coverage area. Now you go into your dictionary code, there's nothing about passwords, right? So you have to look at, was it negligent behavior? And if that is it, then you bring the offense under that. But again, the fairness principle says that, okay, so you expressly cover the offense, but what will the reasonable man, an objective person looking at it, does the conduct justify termination? And if you can give the reason, then fine. Because if you go to section 63.4, it says that the termination of employment is unfair if the employer cannot give grounds, that it was a fair termination. So the burden of proof is on the employer. So if the employer is sure that this conduct or omission warrants termination and they have grounds to, that's fine. They can go ahead.
Another question here. The question is whether you can terminate on the basis of conspiracy to steal. So at any incomplete offense, can you terminate? They didn't steal the money, but perhaps there's proof that they were discussing to steal.
Yes, I like the word you use. There's proof.
Okay.
Now you say the offense is incomplete, right? So you have a scale of punishment. Now, if you terminate, for it to be fair termination, you have to prove that. But for the CCTV which caught them, or for somebody who eavesdropped on their conversation, but it should all come out at the disciplinary hearing. That yes, this was the plan. It's been proven that, but for the time intervention of some surveillance system or some movement control, they would have executed. You can find an appropriate clause to bring them under and let them go. Like I always say, it is not, the standard of proof is not beyond reasonable doubt. It's not even balance of probabilities. It's reasonable belief. But it must be proven. So how sure are you that they were not making the money safer? Why, you don't agree that they can be making it safer?
Well, it was an alternative hypothesis. So.
There was a case where somebody acted in good faith, right? He moved money out of a vote to do some transaction and hopefully to get the money back. I didn't follow the processes. Did he steal the money? No. But he was terminated because he breached operating procedure. You see, so sometimes breach of the rules and regulations, can be at the heart of it. We can dishonesty from that. But it was because you breached the rules. But if you follow the rules, it will be difficult for us to prove any intent in that regard.
Okay. There's a question here that can a person who is suspected of having mental challenges be subjected to disciplinary proceedings for something the person did during a moment of temporal mental challenge?
Yeah, so there again, you realize that there are some defenses that people can use to justify I'll use the word justify advisedly their conduct. Now, at what level or at what time did we know that the person had a mental situation? You know, was it during the investigation that realized that, oh, this person has a mental situation, and so it serves as a defense for the act because he didn't know what he was doing? You know, so that's why it's good to always investigate. Otherwise, you might just treat everybody the same without knowing that the circumstances are distinguished one from the other. So the investigation is very important, and be thoroughly investigated. And if it turns out that the person is a patient in any of our mental homes, the investigator may have to have a word with the doctor to say, look, this person misconducted himself. So is it as a result of the illness? You know, it helps to know what's happening. And of course, if the person has that situation, the burden is on the organization to facilitate some treatment and possibly take him out on medical ground if it is something that incapacitates him from doing the work for which he or she was hired.
Because at this point, there are no discipline procedures questions, so maybe we can ask other kind of questions, like if you had the opportunity to influence the disciplinary procedure space, what would be your most significant input based on all your years of experience?
Oh, I think that the organization must designate people who can serve on disciplinary committees and give them the appropriate training. They must be well versed in the code. They should be able to, because a supervisor can charge somebody, I mean, allege an offense. That's not even in the code, you know, and that stops the whole process, you know, because then there's no case to answer. So I think the designating people and giving them the training would help a great deal to improve the process, because it's during the training that will be schooled on the do's and don'ts and the whys and hows of the process. Will that address your question? Hello?
Mr. Allotey, I'm
Yes.
sorry. Yes, I was muted.
Yes.
Thank you for the alert, Frederick.
Okay.
Frederick has another question. If
Okay.
an employer sets up a disciplinary committee and the committee makes recommendations to sanction the employee in their reports, so for example, they say suspension, can management terminate, dismiss the employee if they think they disagree with the recommendation of the committee?
Yeah, that is where the two policy custodians, the HR and the director legal, must look at. In fact, the first person that the chief executive or MD should call is the director HR, because when the case goes outside the enterprise level to the National Labour Commission, they'll look at your disciplinary code, your policies and procedures, were they followed? Because the employee has signed up to it by accepting the offer of employment. That is why on the onboarding process, you have to make these policies and procedures available so that within the probationary period, if he thinks no, he signed up for the wrong thing, he can safely exit. But once he has signed up to it and it's in the organization, they are binding. So if, for instance, the prescribed punishment for the offense is termination, but due to old boy network, the chairman, the committee members, in their discretion, decided to change the scale of punishment to suspension, it is illegal. They've done the wrong thing. It's beyond their powers to do. So they have to indicate that the punishment per the schedule of offenses and sanctions is termination. However, then they indicate the mitigating circumstances and give why they are recommending the suspension. It is the prerogative.
What if it's not mitigating? What if they recommend worse?
Yeah, if they recommend worse, they should still give the reasons. Because at the end of the day, the onus lies on the disciplinary authority and his advisors, his two advisors, to that is why HR must send it back to the chairman and say that, look, avert your mind to the disciplinary code. You can't do that. It's outside your powers. You see, Article 1911 of the 1992 Constitution, though it talks about criminal trials, it's at the heart of the rights, fundamental human rights, to the principles of natural justice. Because you said from the onset that if I commit this offense, this is the punishment. Why are you varying it now? It means you are bringing in a new law.
Yeah.
Which is also varies, yes. So that one, HR or legal must flag it quickly and save the organization from further embarrassment.
I remember in our earlier conversations, you mentioned that it's important for there to be consistency in I don't want to say punishments, but there should be consistency in the decisions so that it doesn't come off as
Discriminatory.
yes, that for this person it was suspension, but for me it's termination or
Yes. So that's why we have the guide. And also I've been in a situation where I realized that the disciplinary code for junior staff was different from that of senior staff. That's a very wrong situation to be in. It must be a harmonized code, because it's anything that goes against the code of conduct or lay down policies and procedures or standard operating procedure, whether it's done by a manager, senior staff, or junior staff, should attract the same sanction.
I have
And
another question.
It happens
Yes,
because we have different conditions of service. You have a collective agreement for the junior staff, and then they have all kinds of things in there. Then we have the senior staff. But when it comes to the issues the organization frowns on, an offense is an offense. And it must be educated as such.
But sometimes it's difficult because certain levels don't get to work in at 8 o'clock. But sometimes managers or senior C-suites working at any time. Of course, they could justifiably be from a meeting or they stayed late the night before doing office work. But you can't say the manager was late or that top level was late. But then you could tell a junior level that we were late. Could that be some of the reasons why people put in different codes for different levels?
The question of when we report for work and when you got in talks more to the kind of work you are doing and what your supervisor or the line manager says. You see, because somebody can come in late, but there was justifiable reasons. So I remember those days in one of my shops, earlier places I worked, where we had time and attendance, a biometric time and attendance system. HR just pulls the report and sends to the heads of the department. This is the absence and attendance records of your staff. You have to deal with it. We all know that you're supposed to be at work by a certain time. So he walks through, says, okay, AC, yes, no, Kwame. Then he has to have a difficult conversation with Kwame. So in terms of punctuality and lateness, we expect supervision to take care of it. But HR gets the logs, because people have all kinds of funny stories. And also, it has a security implication. In the event of a disaster, you don't want to be looking for persons who are not at work. So yes, but when it comes to code of conduct, there shouldn't be a separate code of conduct for junior staff and a separate code of conduct for senior staff.
Okay.
If it gives it's wrong, irrespective of the level.
I find that sometimes in companies and even in law firms, somebody was sharing. So one team is very flexible. They get to work in at any time they want, and they get to stay home if they think there's not much going on. And the other partners are complaining, or even let's say a company space. The supervisor isn't complaining about the time that his subordinate walks in, but the subordinate clearly walks in late. And everybody knows it's not justified. It's just because the line manager is lenient. At that point, you're going to say something. I think you should. I think you still have an answer for me.
I sat up, okay. Until COVID came, we all believed that staying at work for 8 hours was it, high productivity. We realized that we can still get good productivity from people, working from home. Now, that was not new. Pre-COVID in other jurisdictions, like the US, they have flexi time. The reason being, you are more interested in the output, the outcome. You don't want people to come and sit in the office and be watching the latest Netflix movies and leaving the work. So if the supervisor believes that, okay, one or two members of the teams have some peculiar problems, let's say Kwame used to take the kids home to school, and because the wife is not available, I think that reasonable accommodation should be made, because otherwise then you depend on where he stays and where the school is. He has to wake up at 4 o'clock. He's losing sleep. He will come and take a nap. Say he's picking something from the car. He goes and stretches the back of the seat and catches up. But it's at work. He has scrubbed in. So the management by walking around, which was proposed in the 50s by Peter Drucker. You must know what is happening. Don't be desk bound. You must also have the leader-member exchange, the conversations between you and your team, to know them better and their circumstances. But you don't compromise results. You don't compromise results. If your work program says certain reports must come in by a certain date, they have to come in by that date. If the person is going to run late and needs to negotiate timelines, he should inform the line manager. I'm having a challenge getting this report from this department. Negotiate the timeline. The manager may intervene and fix the problem. But I think that we should focus more on outcomes and results and not be too production oriented that we are compromising on people's issues. Because at the end of the day, we need the people to get the work done.
There's a question here. I think we've answered it already, but for the benefit of people who might have missed it or were not on the webinar, is it right in law to suspend or interdict a staff before the disciplinary hearing?
Yes, it's not wrong. Interdiction, yes, but suspension is a disciplinary action. So if the person will avert his or her mind to LI 1833, that the regulation 8 talks about interdiction. So it is grounded in law. Because see, when you leave people there and they realize that the noose is closing on their necks, and they are very savvy with what they do, they can hide evidence. They can tinker with the IT systems and stuff, and it will be difficult for you. But when they are outside the environment and you've denied them access, you can do unfettered investigations and get to the bottom of the issues. So it's allowed. We don't want people to, and that's why you hear on in the news sometimes proceed on leave, pending the investigation.
Yes.
Yeah, because people are smart. Once they know that the nose is closing in, they can turn into the system, throw in some virus, the whole thing will crash. And you
That's
cannot
true.
get to it. You need very sophisticated IT guys to come and recover your files and stuff. So interdiction, yes. But suspension is a disciplinary action. You must finish the hearing and decide that, like I said, it's a mitigation for a more grievous punishment. So you say that, look, we won't terminate because there are mitigating circumstances. So, but we need to show our displeasure at what's been done. So we'll give the person 2 weeks suspension without pay.
Okay.
And I said, people are advocating looking at section 69 to that. It's a pecuniary, what do you call it, penalty. You're taking money from the person. But the question is it fair to take the money and let him continue to work, or you show him the exit and he has to go and look for his next job?
Okay. Somebody has a question here. Is there any case law for termination with or without cause? If anything can come to the top of your head now, case law for termination with or without cause.
Oh, there is a case law, but unfortunately, I haven't put the particulars here for me to inform you. But there is, and the issue was that there's this principle of employment at will. That force anyone to work for you, neither can they force you to employ them. But once the employment relationship has been made, then the severance of that relationship would require cause. So it's not, that is the determination of the matter. It's not employment at will strictly as you will have in the US.
Okay.
But under mutual termination, section 15, you can mutually agree that this thing is not working for us. So I'll pay you the notice period. And then, or in some instances, you can even add a handshake and the person accepts, and that's it. But there's a case law, fortunately, I didn't record the particulars of that.
Thank you, Mr. Allotey. At this point, I think we can do what I'd like to call the mentoring part. You have the opportunity to inspire all of us listening to you now and who listen to you later. How can we make ourselves stand out in our work?
Ray, that's an interesting question. But what I, in my short time on this planet, will say is that we have to be deliberate about life. We should realize that the only resource we are really handling is time. That's only true resource. Everything we do is within the ambit of space and time. You can only be in one place at a particular time. So the question is, where do you want to be? Is it where you are now? And if you don't want to be where you are, where are you going? What are your options? So I always tell people that when you look at career development, there are two legs to career development. There's the career planning, which is the individual's aspirations as to what he wants to do, who he wants to become. And there's the career management, which is management's prerogative as to what skill sets and experience levels they need to have the work done. So when you move into an organization, you came there on the back of your aspirations. You wanted to join the organization. So you applied and you were recruited. But your aspirations may not be shared by the organization beyond the fact that you can do the work for which you have been hired. So once you're doing that work, and you are not misconducting yourself, they are very happy. But you must have the aspiration that I joined at the officer level, but one day I want to be the MD of this organization. So you always ask yourself, what will it take? What will it take for me to be a manager? What will it take for me to be a director? What will it take for me to be the chief executive? And you have to dress for the party. But you cannot use tenure. The fact that I've been here, I've stayed here for X number of years, and you are banging the table to be promoted. It doesn't work that way anymore. Because the organization is managing careers, looking at who can fill the next spot. So they start with internal job adverts. They broadcast the knowledge, skills, experience they are looking. And if you fit the bill, the job is yours. So sitting down in the organization saying that the organization will manage your career, there can be some disappointments. Second thing is the organizations are, they have a structure of a pyramid. It's only one chief executive, maybe 10 directors, 30 managers, and so on. So it's a broad base and a narrow top. So not everybody who starts as an officer will get to the top. So you need some ambition or aspiration. You must aspire for it. And you must also be resilient. If things don't go your way, you must know that it's only a few people who can be chosen. Many are called, a few chosen. Work to be chosen. Just work to be chosen. I remember I had to do a course in finance at University of Ghana Business School, EMBA finance. And the reason was I went into a management meeting. I was with the bank. And half of the time when the director of finance was presenting, and then
Don't understand anything.
No, I was just sitting there listening to them, and they were having fun,
Yes, OPEX, CAPEX, then they open one Excel sheet and hide the column.
You've said before, right? So when they closed, I went to my good friend, Director Global Markets, Nusa. I said, look, you people were talking plenty there. What are you talking about? Because, of course, I knew about the balance sheets and
Yeah.
but now single obligor swap and
Oh, yes.
stories. So I said, but how long does it take? 2 years. 2 years is a very short time, to address your minds to these. And that's exactly what I did. So you must have some aspiration. You must have some goals in life, something you want to achieve, and have the resilience to achieve it, no matter what. And always make sure that you understand where you are and what is taking place. It will help.
Thank you very much. Sometimes I think these webinars are only for me. I was busy writing away. And I like the part where you said, don't use tenor to bang the table that you should be promoted, which is what we tend to do. I've served the company for this long. I had one boss who said a driver made that statement to him. He said his question to him was, what really have you done for the company? He told him, it's like, we've been here from the beginning and we've served. It's like, yeah, but what really have you done for the company? And the driver couldn't give an answer. So it's like sometimes we tend to forget that contribute value, bringing value to the company. It's very important. Would you hire your own self? Would you promote your own self if you were the one in charge? Will you pay yourself? When you come to work, are you working and giving off enough? Would you pay yourself if you were the one in charge? So thank you. Thank you for that.
You're welcome.
Okay, there's one last question. We're about to close with one last question here. I'm hoping you will, I think there are some intricacies here, and hoping you will catch on to them. Where an employee is found to have committed the offense after the hearing, can the employer net off the half pay given him during the interdiction period from any benefit he may be due?
Yes, the Labor Act under the permissible deductions indicates that if you have, for want of a better expression, taking the organization's money, they can recover the money from you. The only thing that I think expressly is prohibited is the Provident Fund, because now it's been ring-fenced by the new Pensions Act that you cannot, so you have to go after, for you to touch that, you'll be breaching the Pensions Act. So you have to go after the person by letting him know the financial liability, and he should tell you how to recover it. So if he gives you the permission that, okay, I have this money with you, you can use it to set off, then it's with his agreement. But I recall the Labor Act, the one that says that you cannot deduct from the permitted deductions. It depends on how it came about. If it's amount paid to the worker in error as remuneration in excess of what is entitled, if it's to meet a loss suffered by the employer as a result of the loss of or damage to any property or thing used, it's a permitted deduction. So you have to go under a specific provision of the Labor Act, and then you ask what I'm going to do. Say, oh, no, I'll come and pay you. That's fine.
Thank you so much, Mr. Allotey. Thank you so much for promptly responding to our request, for clearing your schedule, trying to make this webinar happen. We are very grateful. And I was happy to see that other people from Human Resource Departments joined in this webinar. Especially for you, from where you're coming from. So thank you so much. So if there are no more questions, we'll end our webinar for today. As usual, we'll upload the recording on YouTube, Lawyers in the Corporate Space, Ghana webinar, so that you can always refer to it or share it with a friend. Our doors are open. Feedback is breakfast with champions. Please, please, please give us feedback how we can make this better so that we can all grow together and benefit together. I'm looking forward to the next webinar, looking forward to see all of you join. And I hope today we have given you value for the hours that you have spent with us. So, once again, thank you. Thank you so much. The fact that people stayed on shows that they must have been learning something. So I'm very, very grateful. Thank you so much.
You're welcome.
And please, the least we could do for Mr. Allotey is to give him business. He's a consultant. So please let your companies go and consult so that this seed that he has sown, I mean, it will be a blessing. So once again, thank you all so much. Thank you for joining. Thank you. I'm going to end the webinar now. Thank you so much. God bless you.